just use the markup of overseas activity.
Yeah, just use the markup of that.
So this is your copy.
Okay. You don't have to.
You want to assist people to come in, not a problem.
Sir, we are live.
Yes, we are on live. Okay, so welcome students for the first lecture on issues in emergent issues in international commercial arbitration. So today we have with us Mr. Naresh Thakkar, who is the partner in economic laws practice. He is the head of the firm's litigation, arbitration, and dispute resolution practice. He has over 20 years of experience in mediation, international litigation and arbitration, especially infrastructure-based project arbitrations and M&A arbitrations. He's also currently active in several professional organizations. This includes the Law Society of the UK, the LCIA, the International Bar Association, and the International Chamber of Commerce, among others. He's also part of the steering group of American Bar Associations, South Asia, Oceania, and India Committee. He is also an executive member of NCIA's Committee on Energy and Power. He is a lawyer and a solicitor qualified in the UK and is a band 1 lawyer for dispute resolution. So today we are here to hear from him on the issue of emergency arbitrators and also the wider issue of enforcement of interim orders by foreign seated arbitrators and the whole panoply of issues there. So I give the floor to Mr. Thakkar. Welcome, sir.
Thank you so much, Professor, and good afternoon to all of you. And I must apologize for being so late. My flight took off later than expected, and therefore I landed late, and therefore I'm late here. So therefore, please do accept my apologies. I'm here to talk to you about, as Professor rightly mentioned, about the emerging issues in international arbitration and the international arbitration space. One of the issues obviously is that of emergency arbitrator, but emergency arbitrator is just about one thing that you hear. There are many other emerging issues, but obviously those emerging issues is not some for today. Maybe that's for some other day. What I do want to do with all of you is that it's post-lunch session, afternoon. People usually want to go and take a nap. I don't want anyone napping. I don't want myself to nap, nor do I want to give you all a monologue. I would prefer to have a session which is more one-on-one, where we are discussing issues rather than me trying to give you a monologue. So feel free to raise your hands, feel free to ask a question. And I think, wherever, to the best of my abilities, I will try and answer those questions for you. I must also, I'm very happy to be here today, and there are a couple of other reasons for it. One is that ELP celebrates its 21st anniversary. So, it's ELP's birthday. And second is that, I do complete in this year my 25 years in the profession. So that's something that, it's a sort of a milestone for me when I complete those 25 years, because yes, it is 25 years well spent doing what I've been doing. And that's something that Harsh and I were discussing on my way here, that how the legal profession in that sense has changed from the time that I joined the profession to where it is today. And it's just for the good, because the sort of exposure that today you are getting, maybe I either I did not get it, or maybe I did not seek it. You guys are in that sense lucky that you are both getting it and you are seeking it. So enjoy the moment, enjoy the ride. Many times, one of the questions that I've been asked very often is, when I go for any lectures, is that what should people do in the profession? And I don't think there is any right or wrong answer, and I don't think there is any answer which is very different from what I had as my own experience in and the journey that I've had. That it takes a whole lot of perseverance. It will take a whole lot of frustration. It will take a whole lot of desperation to be in this profession. and to grow in this profession. So one thing that I must tell you is that don't lose heart as you move forward. It's always going to be that much more challenging, and enjoy the ride. Okay. Anyway, having said the tone for what we are going to discuss today in a very different manner than what you would have expected, let me jump into the topic for the day. So my objective truly is for you to understand what it would mean to be before an emergency arbitrator. Now the question, therefore, prior to jumping into the topic, is to understand what is arbitration. So if anyone of you can raise your hand and tell me what is truly arbitration. We all know it's an alternate dispute resolution mechanism. We all understand all of that, but truly, what does it do?
We can't get to court. There's a prolonged process, and in arbitration you get a quick result. So, I mean, less money, less time, you waste less time.
So how speedy do you think arbitration today in the country is?
I think speedier than the court.
Okay, so that you're right that it is definitely speedier than the court mechanism. It is definitely better than lining up in the courts for your commercial matters. So it is in that sense speedy. But what truly arbitration would mean is that you are resolving those very same disputes, the commercial disputes which you would otherwise take to court in a sort of a private atmosphere. It is hopefully when you are arguing your matter before the arbitrators, you are not in that sense as you would have in the system that we live in. There's a lot of animosity once you enter court. The whole idea is that when you are in an arbitration, you are in a less acrimonious situation than what you would be otherwise in a court-based system. But having said that, yes, it's an alternate dispute resolution mechanism. It is a mechanism which hopefully in times to come will become a true alternate to courts. I'm not saying that it already is not. It is a true alternate to court, because even courts are now pushing for both mediation as well as arbitration and moving things away, trying to move at least the commercial matters away from court. Obviously, you're right, speedy disposal of the matter is something that they look for. In that, if you were in court, you would need what one would understand either as an ad interim or an interim. And those ad interims or an interim could be for various reasons. It could be that, let's say, just to take an example of an LC or a bank guarantee which has been invoked, you would need someone to injunct. If you are the respondent, you are the one whose bank guarantee is being invoked or your LC is being drawn upon, and you know that what is being done is wrong, you would yet need someone to step in to help you, to give you an injunction so as to maintain the status quo until such time as your matter is finally heard. At that point in time, you would want the court to step in. What you would usually do in a suit kind of a scenario is that you will file for an application seeking an interim injunction, which is something not very different in an arbitral scenario also, because you would use what is understood under the Act as the Section 9 mechanism. And in that Section 9 mechanism, go to the court concerned and seek the same relief. Now steps in the EA, the whole concept of EA. Where does this concept of EA come from? So it's not a very new concept. It's a concept which dates back to a point in time when ICC and ICADR had introduced the referee system. So in those years, it was called the referee system. And then progressively from 2014 or 16 onwards, you have various institutional rules bringing in that very same concept as a EA, emergency arbitrator. In the initial years, it was a opt-in system wherein you had to opt in if you wanted, if you were to have an arbitration agreement in your contract, you would have to opt into the system, namely that both parties would have to agree to have a EA a mechanism built into your arbitration agreement. Now, if you were to go by, let's say, the most used rules in India today are the CAC, LCIA, you have the ICC, you have the MCIA, which is a homegrown institution. So these are the institutional rules that one would go. Usually, these are all opt-in, opt-out provisions now, because now if you have once you have signed up for a particular institution, that particular institution will have its own rules for EA. If you as parties do not wish to have that written into your contract, you will have to specifically opt out of it. So that is the change that you see now. But essentially, in theory, what it remains is the same. Whether you call it a referee or you call it an emergency arbitrator, the picture, the scenario does not change. It yet remains a mechanism for the purposes of addressing your emergent or emergency needs, which in all contractual disputes you will certainly run into, and you will at some point in time need the help of whatever court that you would land up in. What is the problem truly in India? And that is something that we need to address, because understanding emergency arbitrator is not that difficult a thing, because this is the lay of the land. This is what emergency arbitration would typically mean. But what is the problem that you have in India? And to understand the problem, you have to go back maybe 7 years, just about the time when the 2015 amendment was being introduced. So if you were to go a little behind, is the time when emergency arbitrator provision had already been brought into the CAC rules. It was already available. So it was available in ICC, it was available in LCIA, CAC brought it in. You had various emergency arbitrator awards, and you must also bear in mind, if you look at the CAC rules, Rule 3, you will find that it talks of award stroke order. And award, let me tell you right away, is a misnomer, because it is not an award. You all know your law. I take it that by now you all understand the difference between an award and an order. An award is something that you get on a final determination of a dispute, and therefore once you have that award, the only recourse available to you is to actually go and challenge it by way of a very limited provision, namely Section 34. There is no recourse other than Section 34 available in law. So no 226, no appeal. It is just an application, and limited provisions, limited grounds are available. And EA, on the other hand, while it is called an award stroke an order, actually remains an order. It does not, the character of that so-called award does not change into an award merely because it is termed as an award. It yet remains an order. And that is very important point that we need to begin with, because this is the starting point of a lot of issues, and how the Indian courts have actually dealt with it is something that we need to discuss. So, as I said, all these rules will have provisions for an emergency arbitrator and provisions for the emergency arbitrator to provide for an award stroke an order on the requirement of the parties for an emergency hearing and an emergency relief. That relief, mind you, is only temporary. It is a relief which will expire, or let me put it another way, it will continue only up till the time that an arbitral tribunal is constituted. That brings us to a question that if the arbitral tribunal is yet not constituted, and also let me pause here and say this, that post the arbitral tribunal being constituted, there is a possibility that both sides, and a very high possibility for both sides, to argue the same application before the tribunal which is now constituted, seeking either the vacation of that order or modification of that order, or whatever else that you may have. Meaning thereby that there is no arbitral tribunal in place. If there is no arbitral tribunal in place, then one of the questions which arises that is an emergency arbitrator an arbitrator at all? And that was the question before the now celebrated decision of the Supreme Court in Amazon versus Future. And that is something that the Supreme Court finally decided. So if you were to pick up your act and look at the definition of arbitrator, it only recognizes a sole arbitrator and a panel of arbitrators, which obviously is a panel of 3 arbitrators. It does not recognize an EA at all. So insofar as the act is concerned, there is no recognition of what we understand as an EA. Now, as I said, step back to 2015 and before. You have an emergency arbitrator provision brought in by the various institutions, namely Singapore International Arbitration Center, London International Arbitration Center, ICC, Stockholm Chambers, all of them have that. But these are all institutional rules. They are not statute. They are not governed by any statute. And if they are not governed by any statute, and if our statute does not recognize, and I'm now talking about local requirements, because we are not talking about Singapore, we are not talking about London. We have no concern with Singapore and London as of now. Whatever may happen over there is not our concern today. Our concern is in India. How do we enforce something? How do we forget enforcement? Enforcement is a far off thing. The first question is it recognized? If it is recognized, is it therefore legal and valid under the statute? If it is legal and valid under the statute, under which provision would you ultimately enforce it? So these are the 3 questions that you would ultimately want to give an answer to, and that's an answer that you would hunt for. So go back, as I said, we keep on going back in point in time and then move forward. So you go back in point in time and look at the definition of arbitral tribunal. Our Act does not have the definition of an arbitrator. It has the definition of an arbitral tribunal. And as I said, the arbitral tribunal definition covers a sole arbitrator or a panel of arbitrators. You have various institutional rules which you opt for. Parties in their contract opt for the institutional rules. Having opted for the institutional rules, what have the parties done? Because arbitration is a mutual process. You and I agree, it's a contract between you and I. So we have agreed now. And also remember, there is another nuance under the Act, and under the law, which is that your main contract may be whatever. Your substantive contract could be anything. In the very substantive contract, you will have an agreement to arbitrate, meaning thereby you have 2 agreements. One is the substantive agreement, which is your main contract, which will govern the relationship between the parties. And then you have a separate agreement within that agreement, written on the same piece of paper, same scroll. But yet, remember this, that it's a different agreement, an agreement to arbitrate. It has no connection in that sense with your main contract. Your main contract may be declared null and void. And there are decisions to this effect. In fact, there is a decision where I had appeared before the Orissa High Court, and it's a reported decision. In that, this was one of the arguments taken, that the main contract actually had been declared as void by the High Court in a 226. The question was that did the arbitration agreement therefore came to a standstill, and why was that? What was the question which was raised before the High Court vis-a-vis the substantive contract? The larger question before the High Court in the 226 originally was that the contract which had been signed, it was a contract between a public sector undertaking and a private party. If it's a public sector undertaking, then under Article 299 of the Constitution, if you would check, you will find that the union, when it signs a contract, it does so under instructions of or on behalf of or signed by the President of India. Similarly, if it is the state which signs the contract, it does so under the aegis of the governor. If today that does not happen, then the contract is void, because, and in my case, it was the general manager of the company concerned which has signed. There's a separate issue that that the High Court did not consider. But anyway, I'm not getting into that. The suffices for today's talk to understand that the contract had not been signed by the governor concerned. It did not have the blessings of the governor. Therefore, the contract, therefore, finally, the High Court said that the contract was null and void. Once the contract was declared as null and void, I had damages to claim from the public sector undertaking because I had already moved man and machinery. Since I had moved man and machinery, I needed to be paid for whatever expenses that I had incurred. And whatever may have been my notional loss, if one can call it a notional loss, there was a loss that I wanted to claim. Question was, should I claim it in an arbitration or should I go by the suit route? Was arbitration a avenue available to me at all or not? And the other side took a plea that there was no arbitration agreement which survived. Why? Because the main agreement had already gone. If the main agreement had gone, the very paper on which the arbitration agreement had been written also goes. It no more survives. Why? Because it is a part of the same agreement. You cannot therefore bisect that agreement to keep the agreement to arbitrate outside the purview of the substantive contract. Obviously, the argument was that the agreement to arbitrate is a contract which you can sever from the main contract, even if it is written on the same paper, even if there is a signature of the person there. It does not require that agreement to arbitrate does not require the signatures or the blessings of the governor. That being the position, the fact that there was a signature of the general manager of the public sector undertaking concerned, the fact that this is now a severable contract, you sever it and it is alive and kicking. That is a position which was upheld by the High Court. It was upheld by the division bench of the High Court and finally by the Supreme Court. And then thereafter, this matter went into arbitration. So important to understand that arbitration as a contract is something which stands alone. This is a point which is important for us to note, because as we move forward into the decision of the Supreme Court, it is important for all of you to understand that once you enter into a contract to arbitrate, whatever are the provisions that you agree upon, in that you also agree upon a institutional rule. Both parties, you and I, have agreed that we will now go by the rule of the institution. Once you have agreed to the institutional rule, can you now today say that, oh, so what if I agreed with you to agree on a rule, on an institution and the rules of the institution? However, if there is an award stroke order, actually let us call it as an order issued under those rules by a arbitrator who is appointed under those rules, I will not honor it. And there is no provision available to you to actually recognize, validate, or enforce that order. And that became the crux of the dispute. If you understand this basic crux, you've understood what Amazon versus Future actually went into. Because the question there also was on various legal questions, whether, the term arbitral tribunal, did it include an EA or not? Oh, it did not include an EA. Look at pre-2015, post-2015 amendment. Pre-2015 amendment, arbitral tribunal definition remains the same. Post-2015, despite the fact that the Law Commission actually proposed and recommended that the term emergency arbitrator ought to be brought into the statute books and there should be an official recognition to an emergency arbitrator, that recognition was not given because the 2015 rules did not recognize it. So the argument that you will face is what? That, oh, but look at it, the definitions don't change. Yeah.
So I have a question. So you're talking about the separate agreement to arbitrate, and then there is this entire main contract. So is this a one box fit all scenario wherein this is always the position of law that the main contract will have to be viewed separately from the?
Yes, and that is the point of law that you must, and it's a point of law that we must recognize and understand, because well, I would not generalize and let me step back, and I could be mistaken. There could be certain scenarios which may play out where you may be able to argue differently, but largely, the position that a contract to arbitrate is a contract severable from the main contract is the position which every court has taken across every jurisdiction. And I'm not just talking about India. If you were to look at English law, you'll find, I'm forgetting the name of that decision, but a famous decision under English law, which maybe I'll share with Professor and he can share with you, where exactly the same position emerged, that a contract to arbitrate is a contract severable from the main contract. So under international law, this is now a well-recognized position. You may, in a given situation, fact-based be able to argue differently, fact-based.
Yeah.
But on law, is this settled law? Answer is yes, it is settled.
Right.
So an emergency arbitrator, as I said, is neither recognized pre nor post. If it is neither recognized pre or post, then the argument against you is that it is despite the recommendation of the law commission, if this is not recognized, then how would you even argue to say that an EA is something which is legal within the four corners of the Indian jurisprudence? So also in 2018, when a further change in law was sought to be brought about, which finally came about in 2019, there was a high-level committee headed by Justice Sri Krishna, which was formed, where again this same proposition was once again reiterated by the high-level committee, because they also said that insofar as you are wanting to recognize institutional rules, you do not want ad hoc arbitration in the country. You all are aware that, I take it that you are aware the difference between an ad hoc and institutional. And I take it that you all also understand that there are tremendous amount of difficulties when you do an ad hoc arbitration vis-a-vis an institutional arbitration. And in terms of cost, while one may be able to argue to say that, oh, but institution also you ultimately have to give, pay fee. But in the end analysis, most times the institutional arbitration turn out to be cheaper than a ad hoc arbitration, and then there are many other advantages of institutional arbitration. But anyway, that's a talk again, as I said, for a separate session. Suffices to say again that for the purposes of the high-level committee, the question truly was that institutional mechanism, should it be recognized and introduced within the four corners of the Indian law? Should that be given a separate standing under the Indian law? And that separate standing has been given, but under a different provision, which is 29A of the Act. Again, that is not something which is up for discussion today. But again, for your understanding, that separate institutional, the institutional mechanism has been given a separate standing under the Act. But within that, one of the other questions, as I said, was that should you therefore give recognition? You have recognized institutions, you want institutional arbitration in the country, then should you not also bring it whole hog? Borrow everything which is good under the institutional rules within your act also. And therefore, in that vein, should you also not bring in and change the definition of arbitral tribunal to introduce a EA mechanism, which would have given an official recognition, a statutory recognition to the term emergency arbitrator? All that they had to do was to say arbitral tribunal means a sole arbitrator or a panel of arbitrators or an emergency arbitrator as recognized under various institutional rules. That is about it. But now here is the situation. 2015, the government did not give it a recognition. 2018, the legislature does not recognize it. So what is the argument against you? Twice over, there is a proposal by the Law Commission and a high-level committee formed by the Law Commission by the legal cell to actually, tell us what is wrong with our law. In that, they say a whole lot of things, including the problem with the timelines, and therefore they bring in the 12-month period. But they have never recognized EA. If that is so, and the fact that the definition of arbitral tribunal lacks the term EA, then how are you even wanting to bring in the orders of EA into the country, wanting to enforce it? To my mind, a great argument, because clearly, if there is no recognition to EA under the law, and twice over, if the law commission is actually advancing this very case to say that bring it into the law, and yet the legislature does nothing about it, a argument definitely, and certainly a good argument to make, to say that therefore there is no statutory recognition. In fact, the statute does not recognize. Forget the fact that there is no statutory recognition, and I'm not right now saying in the negative connotation. I'm saying positively put, it is that the statute does not want to recognize EA. The legislature is aware that there is a lacuna in the law, but it does not want to rectify the law, meaning thereby that the legislature does not want to recognize the concept of EA. Great argument. But obviously, we are an emerging player in the international market. We aspire to be a arbitration hub. Well, we are certainly far away from being an arbitration hub in the international arena, because there are a lot of things that we need to correct before we become a emerging, or rather a arbitration hub. Until that time, we will always remain emerging and all in our mind, and not fully on paper. But again, we will get there, because the law has changed. While the law did not change for 2 decades, it certainly did change in 2015, and then from there it changed quite rapidly, because you had the change in 2015, and then the legislature recognizes further changes required, and then is quick to come in to make that change in 2018. But the fact of life is, for this discussion, for the purposes of this discussion, you do not have the change which you would aspire for, which you would want, namely the change to bring in emergency and to recognize emergency arbitrator. While all of this is happening, you have emergency arbitrators sitting across the world passing orders. They are all sitting in their jurisdiction, passing orders, and not necessarily sitting in their jurisdiction. They are all institutional rules adopted by the parties, adopted by both players in the market, because you cannot clap with one hand, you need two. So both parties agree to an emergency arbitrator. You may have the same institutional rules being applied to a contract and to an arbitration which is India seated. So you have a CAC, you have an LCIA, you have an ICC, all have these rules. We all understand that those rules can be applied to any arbitration. I can be seated for all I care in Timbuktu, but it will get applied since parties have agreed to it. Your seat is India, but the rules that you are following are SIS. With open eyes, you have now taken up SISC as the rules. In the SISC rules, what is built in, and important for us to know, built in is the emergency arbitrator provision, with a provision to opt out. You can opt out of it, but you choose not to. You adopt the SISC rules and you bring it into your contract to arbitrate. A contract which under the Contract Act would be given a recognition as a contract between you and I to do an act which is to arbitrate when our deal goes south. Question is, you have agreed. Yes, and I agree with you, there is nothing in the statute. Legally within the statute, there is nothing to give it recognition. But at the same time, under a very different statute, you have agreed and entered into a contract to arbitrate. And once you enter into that contract, you have to give it full effect. That's something that the courts have always recognized, that once you enter into a contract with someone, you cannot now really, renege out of that contract. You cannot just walk away by saying, well, I don't want to, what is good for me, I will adopt. What is bad for me, I do not want to adopt. So that you cannot do. If you have taken the good, you take the bad as well. And that is exactly what happened in Amazon versus Future. In Amazon versus Future, you have an India-seated arbitration, and we will come to arbitrations which are seated outside the country because there is an added problem there. And we will, we must recognize that what is India seated and how the law will apply to India seated will not apply to what is seated outside the country. So now let us first understand what happens in an emergency arbitrator award, which is India seated. You have Amazon versus Future. The Supreme Court, these all arguments were brought in before the Supreme Court. If you read the Supreme Court decision, question that issues that, arbitral tribunal, no recognition of an EA. Section 17, as you would understand, talks about arbitral tribunal. If arbitral tribunal does not include an EA, then clearly section 17 does not apply. If section 17 does not apply, there is no question of either treating it as an order or an award. And forget all of it. Look at how SISC, terms it. It is termed as an award. If it's an award, certainly there can be no recognition under Indian law, but for a 34. So where is the question? Then again, go back to the point that there is no arbitral tribunal. SISC rules themselves say until such time it operates only such time as an arbitral tribunal is constituted. There is only 90-day window. If within that time 90-day window, and it has happened in one of the matters recently, that the SISC could not make the appointment of the tribunal within the 90 days. And therefore, what happens in that scenario? The emergency arbitrator's award expires. So it has a limited shelf life. Again, another argument, oh, but you have an emergency arbitrator's award. You cannot, it is not a final award. Why? Because after the constitution of the arbitral tribunal can set aside, modify, do whatever it wants to with that award which has been passed by with the award stroke order passed by the emergency arbitrator. Question on jurisdiction. Can an arbitral tribunal can certainly rule on its jurisdiction under section 16. Is that benefit available to a emergency arbitrator? He is not an arbitral tribunal. If he is not an arbitral tribunal under section 16, look at that. Section 16 grants the provision, grants the benefit to who? To the competence principle applies to who? The arbitrator, the arbitral tribunal. So all of this now is the lay of the land. These are the arguments which are, which are being raised. In that, ultimately, there is a recognition which is required to be given to one fact, that even if you were to pick up SISC rules, while it terms it an award, in the same breath, it also terms it as an order. Meaning thereby, and forget the terminology. Let's not get into semantics of an award and an order. Okay, let's not get into that semantics. Question is, what is the purpose? What is the pith and substance? What is the objective of this so-called award stroke order? The only objective of this award stroke order is that it grants you a relief in the interim pending the constitution of the so-called, what Harsh here likes to call a merits tribunal. Okay, which means that you have the tribunal which will actually consider all your challenges of section 16 and the like, and will also take care of the relationship between the party and then decide whether damages are to be given to one party or not. So that's the so-called merits tribunal. But that apart, the EA does nothing beyond granting you a limited purpose relief, which will expire within 90 days if the arbitral tribunal is not constituted. And if the arbitral tribunal is constituted, the arbitral tribunal can modify that award stroke order. Therefore, semantics aside, this is nothing but an order. It's an interim order of a tribunal. We may want to say that an EA stands aside from an arbitral tribunal. We may want to go into the niceties of all the arguments saying that, oh, but arbitral tribunal does not recognize EA, therefore, I will not consider him as a tribunal. But my question to that would be, why would you say that a EA is not covered within the definition of arbitral tribunal under the head sole arbitrator? So what if he is constituted only for the purposes of deciding a certain issue, interim, which will a merits tribunal, so-called merits tribunal, not do? Suppose you get a section 9 order. Today, the section 9 order also has a limited shelf life. The moment you have the tribunal constituted, the courts will generally tell you that I am not going to extend the benefit which has been granted to you. The benefit will only extend to you until such time as the tribunal is constituted. A section 17 application is made, and in that section 17 application, you yet need to seek the same relief from the tribunal, and then it is left to the tribunal to either grant or to continue that relief for you. So what is so different? What is so different that the EA does, which a so-called merits tribunal will not do? It does, to my mind, nothing different. And that is the reason, if you have a provision of an EA entered into your contract, it is like saying that I have adopted SIAC rules. Forget everything else. Forget everything else in the SIAC rules. Concentrate on the fact that you have also adopted. Just allow me to complete this, and then I'll come back to you. You have also accepted the provision which is Rule 3, which talks about emergency arbitration. You have in your contract by hand written that that is something also which you have adopted. Once you have done that, there is no reason for you to escape. There is no escape route thereafter available to you to argue about the provisions of the statute and get into this controversy about what the law commission said and how it has not been given recognition. If you were to go back in point in time to the point when the Singapore law actually did not recognize in its statute EA, even then the provisions for EA existed in SIAC. Even then those provisions were given full effect by the Singapore courts. It is just to do away with all of these controversies we as lawyers raise in courts, and and the creativity that we bring to the table, to do away with that, to plug the so-called hole that the law there in Singapore now recognizes an emergency arbitrator. That was all that the Indian law wanted to do. That is what the law commission wanted. That is what, but the legislature said, I don't need to. I don't feel the need, because within the definition of arbitral tribunal, I have recognized the sole arbitrator. I have recognized the panel of arbitrators. Suppose you appoint a EA today, he will be a sole arbitrator. You will then have a so-called merits tribunal, which can be a panel of arbitrators. Sole arbitrator is the EA who grants you the benefit that you want. Panel of arbitrators is the panel which will decide on the merits of your matter. How difficult is that? And if I don't think there is any need for tinkering with the law, because tinkering with the law is not that great. This is something that I feel very, very strongly about. That you may change the law as many times as you want. You can bring about as many changes as you want. And this is where the mind of a lawyer works. That you will bring about change, I will find a flaw in it. That's the whole point of the profession. The point of the profession is not to find, in that sense, to find a flaw in the law, but to use this law to interpret it to your advantage or otherwise. That's how lawyers are trained to think. That's the training that you are getting over here. Your training is trained to interpret it. So as many changes in law, as many interpretations. And if you go by the Supreme Court decision in Amazon versus Future, Supreme Court says this, that the judicial interpretation of law is definitely available to the courts. So what if the law does not recognize it, and if the law commission twice over said what it said, and yet there is no change in law? That does not mean that by judicial interpretation we cannot recognize the fact that there is an EA, and that that give it full recognition. Yes, both of you. Go.
So if the law recognizes emergency arbitrator as arbitration tribunal, would the merits tribunal still be able to set aside the award given by the emergency arbitrator?
Yes, so, okay.
But
So,
like, wouldn't they be on equal footing according to the law? Both are called
excellent,
arbitration.
yeah. So excellent, excellent. So therefore, what this is one of the other limbs of the argument, which was before the Supreme Court, that ultimately, what are we saying? They are both arbitrators. How can you have a situation that you have one arbitrator who's given a, and again, I mean, you use the term award, okay? You are using the term award, and I have said this, that the award is a misnomer. It's an order. An award and an order stand on two different footings. You can have a partial award in an arbitration. Suppose, and I take the proposition that you put and I take it forward. If it was a partial award, meaning thereby what? That the arbitrator has actually decided upon part of the merit, okay, and therefore foreclosed the arguments of the parties, any further argument of the parties on that portion, meaning thereby that is an award which becomes final and conclusive. Once it becomes final and conclusive, can you seek to challenge it? Yes. Under what provision? 34. You have no other provision available in law to challenge it. Now take the position of what you have said just now, but don't treat it as an award. Treat it as an order. It's just an order. If it is treated as an order, and the purpose for which the sole arbitrator I'm now arguing this matter for myself to say that it is recognized. I'm for Amazon. I'm saying forget everything else. Don't look at, focus on the law. Law is correct. There is no change. Sole arbitrator has been appointed by us because both parties agreed to SIAC rules. Having agreed to SIAC rules, where we are bound by the provision of SIAC rules, Rule 3 talks about bringing an emergency arbitrator for limited purposes. They have appointed the emergency arbitrator for a limited purpose, that is to grant me an emergency order, which otherwise I would have had to run to the Section 9 court. Section 9 court would have done exactly the same thing, sent me back to an arbitral tribunal, where the arbitral tribunal would thereafter be free to modify, alter, amend, set aside, vacate, whatever, not set aside, but vacate that order. What is so different? I am again only asking for the same thing. It's a sole arbitrator instead of the court. Now juxtapose the court, juxtapose the emergency arbitrator in the role of the court, which is what is the recognition that the law wanted to give it. The law has given it by, and more so by parties agreeing to SIAC. We have given that to each other. Having given it, can someone be heard on the other side to say that, oh, but you have now appointed an arbitrator, that arbitrator has given me an award, that award, how can now there be a second tribunal which will set aside that award? It will set aside because it's not an award. And that's the understanding. It's not an award, it's an order. That order can be modified at any point in time. That is the purport of Section 617. That is the purport of Section 9. And think of it logically in a suit scenario. In a suit also, I will, let's say, seek a relief, which is emergency relief. I will seek the court's indulgence and say that I want this emergency relief interim. I need it. Court grants it. Court would grant it on an emergency hearing, would grant it on a so-called prima facie basis. That is an ad interim that the court first grants. So, we all understand that you would first argue for ad interim, then the ad interim needs to be converted into an interim. So I've gotten an ad interim. It could, in certain courts, it happens behind your back. In Bombay High Court, you can't do it. Bombay High Court, you have to give notice to the other side, and only then will you get even an ad interim. But some courts do give ad interim. So I've gotten an ad interim. I'm sitting pretty on it. But you, my opponent, will definitely say that, oh, what nonsense. This so-called prima facie case itself is wrongly put by my opponent. Now I want this order to be vacated. So he will go and file an application equally to the court to say that vacate this order. Then the matter would be argued. Either the ad interim would be made into interim, or the court would vacate that stay. Now, what is so different here? I have an emergency arbitrator's order, which is an interim order, which will finally, because he was there for only a limited purpose, his purpose is served, he's given me an order, mandate is gone. For all you know, he may also be appointed as the arbitrator in the matter. Why not? The main arbitrator, as the main arbitral tribunal, it could be, but assume for a moment it does not happen. So also his mandate is terminated, he goes. You now have a arbitral tribunal of 3 panel or a sole arbitrator, which is constituted, which now is looking at the merits of your case. And when they are looking at the merits of your case is also going to consider a section 70. Once again, why? Because in those 15 days, whatever you got was emergencies. It was an ad interim. It operates only until such time as the tribunal, main tribunal, merits tribunal converts it into an interim. And that's the sole purpose. So if you look at it and consider it from that perspective, then you're not talking about 2 arbitrators, one setting aside the award given by other. It is not an award.
You use the term vacate. How is that different from
Well, the reason why I said vacate is because you can't set aside the order of the High Court. Okay. You can't, as an arbitrator, say, I'm going to set aside the order of the High Court. What you will do is you will say that I now here, I know that there is an order of the High Court which is there, which is in his favor. However, I believe that this order need not continue. So, post the order ending, I will allow the order to die. There is no further order available to you. So, therefore, I have vacated that order. I can't set aside the order which has been passed by the High Court, because the High Court is obviously stands on a much higher footing than an arbitral tribunal. So in India seated arbitration, therefore, now you have, with all these arguments that we spoke about, you now have this recognition by the Supreme Court to say that an arbitral, 2 things that the Supreme Court says, and this is something that we must understand, that it gives a recognition to an emergency arbitrator on the same footing as an arbitrator, meaning thereby that if there was to be a definition of an arbitrator within the Act, the term arbitrator would become the species. The term emergency arbitrator would then therefore be an genus. Okay, so you have the species and you have the genus. That's the first thing. Therefore, it's a recognition of the term arbitrator, emergency arbitrator under the term arbitrator. If you now go back in point, and what is the second proposition that the Supreme Court actually recognizes? Second proposition that the Supreme Court recognizes is that what is passed by the EA is nothing but an order. It's an interim order. Interim order, which is recognized under section 17(1) of the Act. We are in India. We are in an India seated arbitration. Therefore, it is recognized under section 17(1), enforceable as an order of the court under section 17(2). Okay, so far so good. Therefore, in India, the recognition is very clear. Sorry, I recognize that mistake, but so the genus and the species is right. I put it the other way around. It should actually be the other. You see, there you are. Far more vigilant than what I am. But anyway. So you have these 2 recognitions from the Supreme Court. Now take this arbitration seated outside India. You have an emergency arbitrator who gives you an award stroke order. Will it be recognized under section 17(1), and will it therefore be enforceable under section 17(2)? That is the question that we need to ask us. Go back in point in time. I'm now going to ask you to go back in point in time pre the celebrated decision of the Supreme Court in Balco. If you were to go back pre-Balco, We are looking at a situation where there was a dichotomy between part 1 and part 2 of the act. What was the dichotomy between part 1 and part 2? Section 9 provision for interim relief was not available to a arbitration which was seated outside the country. What did BALCO say? BALCO recognized this provision. BALCO did not judicially interpret it to say that that benefit is available. In fact, BALCO said it's a lacuna in law which which can only be corrected by the legislature. I, as the court, cannot now creatively interpret it to mean that part 1 and part 2 both are fused, and therefore section 9 benefit will also be available to a arbitration which is seated outside the country. What did it do? Every arbitration which was seated outside the country where you needed a benefit here, you didn't have that available to you. Sorry. So you did not have that benefit available to you. You could not file a section 9 application. Second problem was you get an order, because whatever you will get from the court outside the country will always remain an order. Question was, how do you recognize it within the country? It's just an order of any other court, an interim order of the court. What is recognized, forget enforced, what is recognized under our CPC is a decree of a foreign court. A decree of a foreign court under section 13 read with 44 is something which is recognized and enforceable, but not an order. So what do you do with that order? How do you recognize it here in India? So that became another problem, which meant that every arbitration seated outside the country had this great problem of an interim, which if the assets were here, if you wanted some injunction against some asset, you would not be able to get it. BALCO recognizes 3 years, the lacuna continues. 2015, the law changes. 2015, when the law changes, within the provisions of section 2 subsection section 2 subsection 2, okay, the provision section 2 subsection 2, there is a proviso which is introduced. Within that proviso, interestingly, recognition is now given to section 9. So if you were to read section 2 without the proviso, go back pre to 2015, it would have only said this part shall apply where the place of arbitration is in India. Finished. Arbitration outside India, no recognition, it does not apply. The proviso now says that provided that subject to an agreement to the contrary, you and I can yet agree to say that that section 9 will not apply to part 2 arbitration. That is a possibility. Provisions of 927 and clause A, subsection 1 of section 3 of subsection 3 of section 37, limited provision 37 would also apply to part 2. So far so good, no problem, because now section 9 is given recognition. For our purposes, section 9 is given recognition. What is not also, we must remember that section 37 in its full flow is not given recognition. What happens is, in this situation, now take your emergency arbitrator. In this light, now take your emergency arbitrator. Section 17 in its entirety is left out of the proviso. Introduction of section 17 is not recognized. You have an emergency arbitrator given order. You want to bring it into the country, you want to enforce it. Under which provision will you enforce it? 70, it is not recognized under 17, because 17 has no recognition under section 2 subsection 2 proviso. If it is not recognized, how do you enforce it? No enforcement mechanism. If you were to go back in point in time prior to the Amazon versus Future dispute, how was emergency arbitrator being recognized in India? There were, like I said, emergency arbitrator orders have been given all the time. The manner in which it was being recognized, and I'm sure all of you would have heard the two famous decisions of the Bombay High Court and the Delhi High Court, respectively, of Avital Post and HSBC, where the courts found a novel way of recognition, but it's a tedious way of recognition. Why? Because there you have to file a section 9. In your section 9 application before the court, bring in the emergency arbitrator order and seek from the High Court an order in the same terms. It is not an enforcement mechanism. Remember, it's not a section 9 is not an enforcement mechanism. It is a mechanism to seek an order from the court. The only way to seek that order from the court is to re-argue your matter and say that therefore please give me an order in identical terms as what the emergency arbitrator has granted to me, and therefore get that court to grant you that order. Tedious, never, all consuming, never ending process. If you were to go by how busy our courts are, you would file a section 9, the other side would ask for time, you will have a month and a half go by before your matter comes up for final disposal at the section 9 stage. That being the situation, does it today is this situation resolved? Answer is no. Even till date, the problem of a emergency arbitrator's order, which is in an arbitration which is seated outside the country, it continues. How will you enforce it? To my mind, because there is no other provision available, and since Amazon versus Future was in the fact scenario decided in a matter which is India seated, will it apply on all fours? Answer is no. It will not apply on all fours. What is the avenue therefore available? It could be the very same avenue that you will have to utilize. Will the courts agree? Largely, my own sense is that the position does not change pre or post. Your section 9 relief yet will be granted to you in the same fashion and manner. So whether now or earlier, the problem does not go away. Your difficulties as a client sitting outside the country does not go away. Your remedy also remains the same. It does not go away. So that recognition that we are all seeking, that recognition that we are all want, will remain within the four corners of section 9, and it does not it does not wither away, so to speak. Will there be a change in law, and is there a change in law required? Given the current scenario where if it's an outside India seated arbitration, this problem will persist. The only view which is possible is to actually give a recognition to an emergency arbitrator within the provisions of the statute, as what Singapore has done, as what Hong Kong has done, as what New Zealand has done. We should now, it's about time that we should now recognize the provision within the four corners of our act to give it the full effect, because ultimately the courts can only do as much. The courts have creatively done whatever best they could by judicial interpretation, but beyond a point, the courts cannot go. As correctly Balco did not, because in Balco that recognition that I cannot do and I cannot go beyond a certain step is something that even now the courts will be unable to do. So that, to my mind, is the four corners of the provision of AEA. That, to my mind, are the four corners within which you as a practitioner will deal with an EA. I think with that, I've covered almost everything which is required for the purposes of this particular provision. I don't know if I have left out any. I don't think I've left out anything on enforcement. Any questions? I would be more than happy to field. I wanted it to be interactive. There was 3 questions asked. Beyond that, nothing. So, but I would want to hear a bit more. Yes, please.
Will you take on from me?
Yes, definitely.
So do you think there is an amendment that is necessary to be brought about in order to make interim orders from foreign seated arbitral tribunals enforceable in India, just like the Untitled model law has?
Yes, to my mind, there is a crying need. There has always been this crying need. As I said, under the CPC also, that recognition that you would get is of a decree, not of an order. So that problem that we are talking about, again, the same thing would happen if you were to get an order from a court outside the country, you would yet have to file a suit seeking interim relief. You will have to argue in the same fashion and manner as you would do under the section 17, as what I am talking about now. The same route will have to be followed in case of a suit. Why make life so difficult for a commercial party? Why not give it? Why not therefore give, as what does the section 13 of CPC do? In effect, what it does is that a court of the same category in outside the country, if I have a reciprocal arrangement with that court, I will recognize the decree of that court as a decree of my court and I will enforce. Why not do it for an order? What is so difficult? Why? Yes.
Okay, so I like with reference to his question, what I see, I mean, we can always adopt the 2006 amendments to the ancestral rules, but when it comes to when it comes to the enforcement of a foreign court's decree, there are certain procedural protections.
6 of them. You're
There
right.
are around 7 protections, and so when you have an order, if you have to give effect to so many procedural protections, I mean, the
It becomes difficult.
purpose of an interim ad interim is probably lost.
So you're so right. You're absolutely right. And but does it resolve your situation to say that I will not have similar provision in the CPC? It does not. You sail in the same boat, at least by saying that I will recognize an order of see, also we must understand, if you were to go back to CPC, there are those 6 or 7 points under which one of them is whether natural justice has been followed or not. Did you have enough notice and stuff like that? Was it made in was the decree made in a proper format, proper manner? Out of those, you can cull out the provisions which are important for the purposes of an order. You need not borrow every provision. You need only to cull out 2 or 3, maybe most important, and bring it for the purposes of an order so that you can give an immediate recognition to that order and enforce it. Because if you cannot, what happens is that I have an order, but it remains paper. I can't enforce it in this country. By the time I come here and I get to enforce it, a few years would have possibly gone by. The whole purpose of a commercial party is to seek protection. The protection is lost. My entire commerciality might change within 2 or 3 months, and it does happen where you have an order. If the other side is creative and he wants to, make life miserable for you, and this happens number of times in a shell company. What is a shell company? It's either one asset company or it has no asset at all. It's a shell company. You can't enforce it at all. Or one asset company, the asset is sold. You are doomed. You can't run after that because it is your order is not called the asset. Order is called the company. That's it. So life becomes that much more difficult. It does not resolve. You're right. It will not immediately help everything. But if our courts, and this is something that is aspirational, if our courts were to function in the manner that one would expect it to function, again, not blaming the courts, they are today extremely, it's the system's fault and not the fault of the judges, because they are extremely overworked. But assume for a moment that we were in that utopia scenario. Then in that case, yes, I may get an order, and in the next 2 days I may be able to come here and enforce it. Get at least an ad interim from the court here to say that at least until such time as I give a final relief, you or finally dispose of this application for enforcement of this order, you will not dispose of the property.
I think she had a question.
So I was just asking if at present the revenue agreement for enforcing the award given by an emergency arbitrator in a foreign city dispute would be to approach the high courts and ask for a relief under section 9. So basically ask for the same relief as given. That's by emergency arbitrator.
Yes, that's exactly the point, that you will have to ask for the same reliefs. And you can't go and tell, and that's the reason I said it's not an enforcing court. Section 9 is not a court for enforcement. Section 9 is to grant you interim relief. Now, also take another nuance. Okay. You have an emergency arbitrator provision, and this I'm now talking about an India seated arbitration. You have an emergency arbitrator provision which you have adopted, both sides. Can you go in a section 9 to the section 9 court? Will you be able to approach the section 9 court? Because if you guys were to look at your act now, post 2015, once an arbitral tribunal is constituted, you have no recourse in a section 9. Is there a possibility of some court telling you that you have a relief under EA, go to that court, why are you coming to me? The whole idea of section 9 and the provision being changed is lost. The whole idea of you adopting an EA provision is lost if you are to come to me. The whole idea of an EA is decongest the courts. What are you doing? You are bypassing that, coming to me. But if there is a situation where your remedy under EA is not efficacious, which is section 9 subsection 3, can you now go back to the section 9 court? Yes, you can. You can. So you're right. The section 9 court is not a court to enforce. The section 9 court is for a very limited purpose.
So like, what's the legislative intent behind it not yet introducing the amendment is referred to? Because I mean, it seems reasonable in all the aspects that you argue, but like,
I wish I was sitting at the as a legislator. I wish I knew the minds of the legislator. It is very difficult sitting where we are to predict why it is not being done. It is very difficult to predict why the definition of arbitral tribunal was not changed to bring in an EA. It should have been done. It would have resolved all these controversies. Amazon versus Future would not have happened.
in the justice report that the agency that was set up, they were looking at institutional arbitration. They cited that the lack of practical awareness, even with respect to institutional arbitration, is one of the reasons why, you know, there has not been a lot of effect to what we talk about in terms of, you know, theory that this should have been done and that. So like, would that be one?
I don't think so. At least you will give, you will say that the legislator is aware of, the legislature is aware of the requirement. The legislature wanted the high level committee to come up with an answer. They came up with an answer. They wanted the recommendation. Recommendation was given. This was then for the legislature to adopt or not adopt. Now they chose not to adopt it. They chose not to go with it. But can you now say that, oh, but they are unaware, or they are unaware of what problems? No. The high level committee, you formed the high level committee, the high level committee has looked at everything. They are telling you that institutional rule is the way forward. If they are telling you that is the way forward, why would you not adopt it? Yes.
So do you think eventually they would, like within a few years, considering India wants to become the arbitration hub, so they would be forced to do this?
See, I'll tell you one thing that, you know, there is a lot of criticism about India being where India, even today, there is a lot of criticism in the international diaspora. Whenever I travel, whenever I, you know, talk to my colleagues in different countries, there's yet a lot of, and I don't think it is going to go away in a hurry. It took us 2 decades to bring the first change in law, when we actually know that from 96, the time that I started practicing, to the time that the law changed into 2015. I mean, there was no change. If you look at the jurisprudence in between this time, there was so many decisions which are contra, so much of problem. Your 1940 Act had not worked. That is the reason you wanted the 1996 Act. You adopted UNCITRAL, but then you didn't adopt UNCITRAL model law in its entirety. There are lacunas, and then you also need to understand that there are cultural issues which arise, there are legal issues which arise within the 4 corners of your own legal system. So in the 4 corners of our own legal system, we have our own problems. But we were slow in making that change. But when the change happened, it happened rapidly. You had 2015, you had 2018. Now the question is, we are yet being fanned. Why? Because of all the issues which are there. So will it, at least Amazon versus Future resolves one part of the problem? Will now there be another change in law? Anybody's guess. The legislature may want to do it, and they may want to do it also because, please understand, we are an economy which is growing. We are possibly as IMF has predicted, in the next 5 years, at least if nothing else, the 5 years belongs to us. if not the decade. It should. But if it does not, at least the 5 years. Every other economy is predicted to grow at 2.5%. We are predicted to grow at 8.5%. You shave off, you tell yourself 8.5% is too much. Who grows at 8.5% in today's times, and with recession, we are staring at recession, it will not. Shave off 3%. Fair to say 3% shave off, yet you will be growing double the rate at what the world is going to grow. You want we are in crying need of infrastructure. We are in crying need of everything. That's the reason you have so many. Your just outside your school, you have the highway which is being made. So if all of that has to happen, and if people are invited today, there are various schemes that the government has floated. One of them you will read in the newspapers is about a incentive scheme on Make in India. You come, you invest in India, production linked incentive scheme. Come, Make in India, I will grant you a benefit. What is the benefit? I will immediately give you an upside on your price when you go and pitch for and bid for a government contract. It's huge. Why will I not take it? Now, if you are going to give all of this a push, businesses will fight. Human nature. To fight is human nature. Businesses will fight. You will need resolution. If you can't have speedy resolution, why will I come to your country? I am investing so much in your country. And if I have, let's say I'm a fund, I come into your country, and while I'm exiting, I have to exit with, I have so much of heartache and heartbreak, and I have to argue all these points. Then am I, going to be happy to come in? Answer is no. So the change in law, as what you have seen, has happened by the government with this entire recognition that, there is a requirement. Government, in fact, wants to give this a push. Why? Because the government recognizes it is not easy to resolve the other problem, which is the problem of the courts. They are not going to be able to decongest the courts that fast. Courts need an infrastructure, manpower. All of that needs money. We are in a federal system. So every state has to prop up its own court system. So every court will not grow identically. Some states may invest, some states may refuse to invest fully. So there are many, many issues. So when you and I sit dispassionate and away from all of this, we don't realize that there are many problems. There are many issues that are there, and all of them are not immediately resolvable. This possibly is, and that's the reason the government is giving the 2 changes in law, and hopefully the 3rd change will happen.
So how will the third party funding and arbitration help these issues out?
It does not. It does not help any issue per se. All that it does is that it helps warring parties to fund themselves. So I don't need to use my cash for the purposes of fighting my own dispute. Is that a happy situation in India? I don't think so. People have not as yet grasped fully what it means to get in a third party fund. A third party fund is not going to walk in because you want money, and they are not interested in your awards, because your awards will take that much more time to be recognized and then enforced by the courts. They're not going to wait for 5 years and if they wait for 5 years, then the discount that they will seek is tremendous. And then they will also sit and look at your entire matter. They will want to understand whether what you are, because in India we have a habit. If I have a claim of 100 crores, I will say, you owe me 1,000. Why? 1,000 manga to koi 100 dega. That's the mindset. You have to get out of that mindset to say that I will ask for 100, but I know that my 100 is real and I am backing that 100 up fully. But that we don't do. We ask for 1,000 when we know that what he owes me is 100. So that hopefully, this is what. So third party funding is a different ballgame altogether, and the third party funder is going to look at all of this. But third party funder does not necessarily resolve all of your all these problems. It does not.
Any more questions? So I had one last question. I mean, I don't know if I should be, because this is a really long conversation. But if like what my understanding of how Singapore has accommodated it is that there's a standalone provision for EA rather than treat this as a tribunal. Because if we treat this as a tribunal, there are rights and liabilities associated with being the arbitral tribunal, like there is this disclaimer, protection against bias, termination, disqualification, arbitrators misconduct, even jurisdictional questions. So suppose if this EA comes and I argue that the interim relief that is being sought is pertaining to an accepted matter. If he does not have the jurisdiction to deal with the jurisdictional question, I mean, will this be workable if we treat the arbitral, the EA as a regular tribunal?
It will, to my mind. In fact, in Singapore also, if you look at pre and post, in either circumstances, the same things that you spoke about apply to the. Did an EA not have to give a disclaimer? Yeah. Did he not have to give a disclaimer saying that, I am not conflicted? Did he not have to say that, did he not have to follow all paraphernalias of a regular tribunal? Yeah. There's no difference. I will not have a person sitting there as a person who's going to give me interim relief if he is conflicted.
Yeah.
So it is not as if that the entire 9 yards do not apply to a EA as it would apply to an arbitral tribunal. Everything that applies to him would also apply to an arbitral tribunal. Importantly, today, one of the other problems, and now good that you brought this up. Question is, and as I mentioned to you, if you look at the proviso to section 2, subsection 2, it does not recognize section 37(1)(b). Meaning thereby, and actually if you ask me, there is no challenge possible to the jurisdiction of an EA. So if the EA recognizes it, that he says that I have jurisdiction, so he's going to go ahead with the matter. If he goes ahead, there is no appeal provided. Appeal is provided when, if he gives up his jurisdiction in that limited circumstance. But if he assumes jurisdiction, there is no appeal provided in the act at all. And to my mind, do we need to tinker that? Answer is no. You don't need to do anything. It is what it is. He is there even for a limited purpose 90 days later. And which court does not make a mistake while granting an interim?
So if appeal is not allowed, but when the arbitral tribunal is constituted, then their award would be
exactly. So exactly. So therefore, why tinker with the law for those 90 days? It's only a 90-day thing. Every institutional rule has that thing saying that it will the order of the EA would only be valid for a limited time. So why change the law on jurisdiction? Once you change the law on jurisdiction, then in India, the first thing that the party will do is file a section 16 application before the arbitral tribunal, before the EA, to say that you don't have jurisdiction. So first issue that he has to deal with is to now fight that battle and decide. Here he can decide and life will continue.
Just a follow-up question to what the person was asking, and I think you were not earlier. So, in case, I mean, it might arise theoretically as a question that if emergency arbitration is considered an arbitral tribunal, I mean, if they are considered safe, then we know that two arbitral tribunals cannot function parallelly.
But here it is not functioning parallelly.
One is merit based and one is only deciding on interim basis.
Yes. So therefore they are not running parallelly at all. I mean, they are not. So it is different to say that both are functioning at the same time. Can I have two arbitral tribunals going on at the same time? But that is not so. His mandate comes to an end the moment he passes an order. That's it.
Any more questions? Okay. So thank you, Mr. Thakur, for your very enlightening presentation, and thank you, students, for your patience. I also thank Archit for helping me organize this. I hope you can interact us more and we can see you more often on this campus. We look forward to working with you. And thank you so much for giving this.
Thank you so much for having me over, and thank you truly. I do appreciate. Thank you so much for your patience, especially after I walked in 1 hour late. So great to see almost all of you around. Thank you.
Thank you.
It's a pleasure.
Thank you. Ajay ji, you can stop the YouTube. Thank you.
Yes.